Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. Vindicated numerous times. That's what ML Party List Representative LEILA de Lima felt after a Muntinlupa court reaffirmed her 2023 acquittal from drug charges. De Lima says despite efforts to silence her and erase the truth, she vows to continue to stand up for justice. Let's get on point with ML Party List Representative LEILA de Lima. Good evening. I have to get used to saying Congresswoman.
I'm also not used to it.
Kasi senator pa rin ang pagkaalala natin sa'yo.
Naalangan pa ako na tinatawag as representative. So good evening, Pinky.
Congresswoman, good to see you.
What an honor and pleasure to be here in your program, On Point.
Thank you.
So I like the title of your program, On Point.
And that's what we're going to do right now because, again, you were acquitted by Judge Alcantara, if I'm not mistaken. Abraham Alcantara, of Muntinlupa RTC. And basically citing, reasonable doubt dito sa drug charge against you, which he already, acquitted you in the past. Just for context, siguro, so there's a better understanding, Congresswoman, the CA, the Court of Appeals, hindi ho ba, voided the decision of acquittal by Judge Alcantara to you and said, please rewrite your decision.
Essentially.
Bakit humantong doon? So maybe you can explain.
Of course, we also cannot understand that. It was perplexing to us that's the disposition on the part of the Court of Appeals. In the first place, the very fact that the petition as filed by the Office of the Solicitor General was not dismissed outright was already questionable because it was violative of the constitutional prescription against double jeopardy. We do not see any applicable exception, okay, because the rule on double jeopardy is not really an inflexible rule that it would not admit of exceptions. We agree that it has exceptions, that when you are acquitted, you're not supposed to question that anymore. It's final, unappealable. That is the general rule. Now, it admits of very restrictive restrictions. Kailangan mayroong yung sham trial, mistrial, violation of the right of due process on the part of the prosecution. How can there be a violation of due process when they were able to present evidence and nagkaroon pa nga ng rebuttal? And then also grave abuse of discretion in exceptional circumstances. So none of these four recognized exceptions under jurisprudence is applicable in our case. And yet, the Court of Appeals accepted the petition, ruled in it by saying that, okay, the decision of the court in May of 2023, which is the judgment of acquittal, is null and void, and therefore we are remanding this to the court for the rewriting of the decision because it was saying that may mga kulang-kulang daw dun sa rationale, dun sa justification for acquittal. I've been asking around from legal practitioners, from law practitioners, whether they have encountered such a situation before.
I was going to ask you that.
No, it's unprecedented. I don't think it ever, because it never really said that the acquittal was wrong, that the acquittal was invalid, that it was not correct or it was not right for the court to acquit me from the charge. That's the second of the three cases filed against me. It only says that, okay, the decision does not seem to comply with the requirements of the Constitution on what should be stated in a decision of a court of law. So binalik. And then the trial court judge willingly accepted it. But you see in his decision, released only last Friday, June 27, it stood firm. It says that my earlier decision was already sufficient. But out of respect, deference to the Court of Appeals, I'm coming out with this modified decision just to satisfy the Court of Appeals.
So are you saying that Judge Alcantara, in acquitting you once again, did not answer some of the questions of the Court of Appeals, to which I remember the Court of Appeals asking that the decision of Judge Alcantara was merely based on the recantation of a witness, si Ragos po, na earlier testified against you, tapos sabi nga niya, pinwersa lang siya, and that the CA said that the judge did not specify other issues why LILA de Lima was not guilty?
Well, in the new decision rendered or issued last Friday, it already addressed the concerns of the Court of Appeals. Okay, it already explained, quoted the portions in the transcripts about the answers of Ragos in his recantation. And so the conclusion still that the recantation was valid because there was no showing at all that the recantation was influenced by any consideration like monetary, like coercion, like pressure, and whatever, ill motives. So no showing of that because he was
voluntary.
Ragos, the key witness, really stood firm, stood his ground. He was subjected to hours of cross-examination by the prosecution. If I'm not mistaken, it took 3 hearings, several hours, 10 hours or more than 10 hours for cross-examination, trying to break his determination in his recantation. But he stood his ground. All the things that I said before, the previous testimony wherein I said that I delivered money on 2 occasions in my residence, 2 occasions, 5 million each, that's all false. So the prosecution, of course, was trying to break him. But you know that your recantation now is out of other consideration, but it's not. So it was not broken, it was not nullified, and the court said that the recantation was valid. And in our view, in my view, Judge Alcantara was saying, without the testimony of Mr. Ragos, because he is the key witness, there is no other evidence to show my link,
your involvement,
in the illegal drug trade.
I think, Congresswoman, if I'm not mistaken, I recall that the establishing of drugs inside Bilibid was, rather, it was established.
Yes, it was established.
But it was not established, except through Ragos, your participation.
Yes.
Until Ragos recanted and said, pinwersa lang siya at pinilit lang siya.
Yes.
Okay. So that was the only link, kumbaga,
correct,
of your personality there. All right. How did you, maybe, I guess, when you found out that the Court of Appeals voided that particular decision of Judge Alcantara, how did you feel at that time? I mean, wala na kayo na. You had finished 2021, tapos na yung kaso 2023, that was the case.
This is the 23.
And then 2024.
The last one is 2024.
Right, but in 2023, you were already out on bail. Hindi ba?
November 2023, for the 3rd case, for the remaining case.
For the 2024 case,
Kasi yung first 2 cases, the first one dismissed in 2021, I also applied for bail there, but was never acted upon. And then the second case, this one, the acquittal by Judge Alcantara, I also applied for bail there, but it was also not acted upon. Now, in the 3rd remaining case, nung tapos na yung 2 case na yun, supposedly, including yung kay Judge Alcantara, the court granted my bail, granted bail in November 2023. That's why I was out on provisionally out on bail. November up to June 2024, when the 3rd case was also finally dismissed. So I could say that I attained complete, unmitigated freedom. Yeah. And here comes the Court of Appeals decision.
That's why I wanted to find out what was going through your head, after being acquitted in 2024 with 3 cases already, that you had to hurdle a previous case that you were acquitted for.
Yeah.
Ano yung naging pakiramdam nyo? I mean, did that somehow, bring back any ill feelings, pain?
Well, I was, of course, dismayed. First, I was surprised, because even on the part of my legal team, we were confident that nothing would happen to that case, the petition for certiorari filed by the Office of the Solicitor General. So I'm thinking talaga na, madi-dismiss lang yan because it's clear, acquittal, it's acquittal. It's supposed to be final, and there, again, no applicable exception to that rule on double jeopardy. So we were confident. And then finally, eto nga, instead of dismissing it, because of that, the rule on double jeopardy, ay pinakialaman and then pinasauli dun sa trial court at pinasulat muli yung desisyon. So I was very dismayed. That's why I have to say that I've been vindicated multiple times. You know, there's those cases one by one. It was dismissed out of my way and then vindicated also because the truth has been coming out. You know, some of the witnesses have recanted or signified their intention to recant. And then the hearings before the Quad Committee, which shows who are the actually involved in the illegal drug trade. So I felt vindicated because that's what I've been saying all along. You know that with respect to the culpability of the Dutertes, also in the DDS killings, and all that, because it originated, my case, my persecution originated
when you were DOJ secretary.
When I was CHR.
When you were CHR rather, yeah.
Because
nauna pa pala yun.
Nauna pa, noong 2009 pa yung DDS, and then SOJ, and then Senate, especially sa Senate. Kaya nga ginawa yun sa akin. I was first ousted as the chairperson of the Committee on Justice and Human Rights when I started that investigation, and especially after I presented Mr. Edgar Matubato as a witness there. So the majority of my colleagues in the Senate ousted me. So, and then nagkaroon ng that, you remember that hearing in the House of Representatives, that kangaroo hearing, you know, the slut shaming and all that. Kulang na lang talaga itapon sa akin yung buong kitchen sink. And then that resulted in the filing later of those bogus charges. So eto na naman. Bakit you know, dumaan na nga, and I willingly subjected myself to the scrutiny of the courts. I did not escape. I did not evade justice. And I continued, even if it was difficult for me, I had to continue keeping my faith in the justice system. Because it is only within the justice system that I could be vindicated. Nowhere else. Saan ako pupunta? Mamumundok ba ako? Tatakas ba ako? I could have applied for asylum. I knew I had good basis for asylum, and unlike the other one, has applied also for asylum over there at The Hague.
Attorney Harry Roque.
Yes. Mm-hmm. So I think if I applied for asylum, it would be granted because there was clear case. We could easily show that it was a case of political persecution because of my stance against the extrajudicial killing. So ito na naman, bakit hindi ako I hope this is the end of it.
I was actually going to ask you that. Is there anything pending?
No more?
Because I was trying to read, I don't think there's anything pending among all
These cases, the drug cases, none, because there were only 3, and all of them have been dismissed already.
You were in detention for, is it 2454 days? 2,454 days?
2,454 days.
2454
days. 6
days.
years, 8 months, and 21 days.
Congresswoman, is there anybody that you will have a hard time forgiving?
Yes. The principal, the foremost principal, my chief oppressor, no other than the former president. I've been saying that. I have already forgiven the rest, all of them, including the former Secretary of Justice. I've forgiven him already. And all those who aided, those who acted as handlers of these witnesses, and especially those witnesses, every one of them I've forgiven already, even though most of them did not ask for forgiveness. Only about 2 or 3 of them asked for forgiveness. But the president, the former president, not yet. I'm not ready to do that.
2,554 days.
2,454
days in detention. When you were out, I remember I was able to speak to you. You were on your way to Manawag, I think the day after, and you were actually being told, advised not to go for security purposes. Of course, those people have supported you, are very happy, enthusiastic that you had been acquitted. Now it's a different chapter, you know, it's a moving on chapter, and you are now going to be, well, you're a congresswoman already, and you will be part of the public prosecutors against Vice President Sara Duterte.
Just clarify that I'm not yet officially a member of the prosecution panel, because it's just yesterday that me and Representative Chel Jokno became officially members of
the
20th Congress. So we're just waiting for the notice from the House, maybe the House leadership, as to our appointment as members of the panel.
But there's number one, there's no turning back, and there won't be any change of mind from the House or yourself and Congressman Chel.
Yeah, on my part, no, because I said yes already, and so did Congressman Chel. We said yes already to the invitation, to the offer of Speaker Martin Romualdez, but as to the official action of the House of Representatives, we still do not have that.
When do you think this should happen? Because just so there is no confusion here, the House already submitted its manifestation with resubmission of entry of appearance, meaning yung prosecutors po ng 19th Congress re-entered yung kanilang appearance, but without you and without Congressman Chel Jokno yet. When do you think this will happen?
So there's got to be a supplemental entry of appearance where the two of us will already be part of the panel. Now, it could be at the first regular session, the first session day of the House after the SONA.
I question that, Congresswoman, because hindi pa pwedeng ngayon, because you're already officially part of the 20th Congress, and in fact, there were House prosecutors who were saying that it's possible that the impeachment, or there could be a pretrial, a schedule of the pretrial now, between now and July 28th, during the President's State of the Nation address. What are your thoughts on that?
Well, it can be now and later, but it really all depends on the House leadership. They can in fact invite us already in their meetings, even if we're not yet officially members of the prosecution panel, just to get to know things and get to know what's really happening, the developments within the prosecution panel. There's no legal impediment about that, but maybe they're eyeing a collective action from the House of Representatives that they would officially name us and nominate us as part of the prosecution panel as new members in addition to the current members of the prosecution, because there's supposed to be 11 members of the prosecution panel, but I understand 2 were not re-elected, and so Congressman Chel and I are
we
here.
Will replace them.
Yes, we have not received any notice or any information from the House that they're taking back their offer to us as members of the panel.
I'm just making sure that you're still there, because with the intent of the House prosecutors to kind of fast track this impeachment and to begin.
Yes.
That's why I guess I'm questioning why there hasn't been an entry of appearance for yourself and Congressman Chel. So is there a doubt here anywhere that there's a change of mind on their end?
Although it is possible, it's not impossible, within the realm of possibilities, pwede yun, but I doubt, because I have not really known of any information, of any notice about that, or any sense about that.
Okay.
And I think we will be part of the prosecution panel.
There was an interview with the spokesperson of the Senate that I was able to see earlier today, and he was saying, he was asked about what are the pending manifestations for the impeachment court that they have yet to receive. And he was saying that one is that the entry of the prosecutors, that's one, which was probably include you and Congressman Chel, kasi nga bago na po ito dahil may bagong public prosecutors ni Huba from the 19th Congress. And then the certification that the 20th Congress will continue what the 19th Congress did. So we finished the first one, no? Kasi kailangan po yung submission with you and Congressman Chel. What about the compliance of the 20th Congress that this will proceed? What do you think of that?
It's actually, to me, it's a source of discomfort in the sense that I think the House of Representatives should really be careful about how they comply with those orders. Kasi di ba yung una about the certification that is compliant with the constitutional requirements. Although they explained that in the reply of the prosecution, that, okay, there is that return, but it has not really, the House of Representatives has not really received the articles of impeachment. They deferred the receipt, although it's being returned to them. But they still issued that certification through a resolution. Because delikado kasi yung masyadong, you know, since these two things that were required of the House is actually, to me, improper. That's not sanctioned by the Constitution.
Let's identify them again, Congresswoman, for the benefit of those watching us. The certification that the impeachment court is asking from the House, dalawa po yun. Go ahead.
Yung dapat compliant daw with the constitutional requirement.
With the 1 year ban.
The 1 year ban. Again, well, it's not proper. It's not sanctioned by the Constitution because there is supposed to be a presumption of regularity. Insofar as the House of Representatives are concerned, tapos na yung trabaho nila that is initiating the complaint. And that's why they forwarded the articles of impeachment. Ang remaining trabaho na lang ng House is through its prosecution panel to prosecute, to participate in the trial, and to prove the charges against VP Sara. So that's the only remaining work of the House. Ginawa na ng House yung pinakatrabaho niya to initiate in accordance with the Constitution and with their own rules. So bakit kailangan mong ibalik, ipa-certify para sa akin, the very fact that they transmitted that articles of impeachment already in February 5 to the Senate, that is the very certification because that is verified. That complaint is verified. So unnecessary, not sanctioned by the rules. Ito na naman, the second one is even worse. Imagine requiring at that time, as of the 19th Congress, requiring the House of the 19th Congress to certify that the House of the 20th Congress is willing to pursue the impeachment case. There's no need for that because the premise, the right premise is that the impeachment case can cross over from the 19th to the 20th Congress. So why the need for that certification? Unless there is a categorical move or action on the part of the House of Representatives as a House, as an institution, that we are withdrawing everything already.
That should come from them.
That should come from them. And the Senate should not be pushing for that issue.
Why do you think that is being done?
Because I think it was a sort of just, remember that it all started with the move of Senator Bato. Yung sinasabi niyang de facto dismissal, a motion to dismiss. But they did not expect the public's reaction. A lot of reaction from the public, you know, all those statements issued by various institutions, by law schools, and then by legal luminaries, and then the statement of Justice Adolf Ascuna was the author of Article 11
of the 1987 Constitution.
Of the 1987 Constitution. So nag-ano sila, nag-Rumeno sila, you know, and as a sort of a semi-Solomonic solution. Ayaw naman nilang pahiyain si Senator Bato. And perhaps the initial intent was really to dismiss. Remember that statement of Senator Bato? We have the numbers, right? And that means they have the numbers to dismiss at that point. But they did not anticipate, again, the public reaction. So they have to backpedal. And so pumasok ngayon that amendment, the so-called amendment from Senator Alan Peter Cayetano. Hindi na nila masyado na pag-isipan yun eh. Basta they have to do something to address the situation because they cannot directly dismiss at that point and at the same time have a reason not to. Mm-hmm. And that is, i-dribble muna, ibalik muna natin sa House, forgetting already about these basic principles about the that these are supposed to be co-equal institutions.
Congresswoman, if the House hypothetically violated the one-year bar rule because the Constitution states that an impeachment complaint must be included in the order of business within 10 session days, I understand that that will be questioned, certainly, with this impeachment complaint. Just hypothetically, if there was a question about it, do you agree that the impeachment court can question that? Or is that something that the defense should question either to the impeachment court or to the Supreme Court?
It should be the Supreme Court. I mean, the defense can raise it, should raise it, and it has, in fact, the defense should not have raised that. I mean, they have, theoretically, they can always raise anything in their answer, and that is, in fact, raised in their answer about the violation, the alleged violation of the one-year ban rule. So, nandyan yan. But my position is, pwede ba na i-dismiss ng Senate? No. Kasi nga, the question of any reasonable lawyer should not be, where is it found that a dismissal is not allowed? It should be, where is it that says that dismissal is allowed?
But what if the premise is wrong? What if yung pinanggalingan, for example, I raised that because I had attorney Salvador yesterday, and he was saying that if there is something wrong with the premise, then if you continue on, for example, mali yung sa House, if the impeachment court proceeds with it, there could be something wrong there. I mean, in so many words, that's how I understood it.
It's probably raising the issue of jurisdiction. Because, you know, kapag walang jurisdiction, null and void. So all the proceedings are null and void. But it's not really, it's not as simple as an issue of jurisdiction. I mean, any issue with respect to trying to or attempting to dismiss or derail in any manner the impeachment case should not be before the Senate itself as an impeachment court. It has to be a constitutional issue raised before the Supreme Court, and I think they have that pending petition, and no temporary restraining order has been issued so far.
Just yet. You were obviously in the Senate, but you were never part, I believe, of any impeachment complaint in the past.
No.
So we often heard Senate President Chis Escudero say that the plenary rules. In other words, if there's a motion by any member of the Senate, whether it would have been you in the past, for example, and goes down to a vote, and majority, they get a majority vote. That majority vote obviously wins.
It's wrong to say that an impeachment court is a plenary court. It's a plenary body. You know, plenary, the Congress, the House of Representatives, or the Senate is really plenary or has plenary powers insofar as its legislative function is concerned, because that is something inherent in their body, in their institution, because that's their core mandate, lawmaking. But you don't talk about plenary powers when it comes to impeachment cases, because impeachment is supposed to be specific. The mandate of the Senate as an impeachment court is so specific, meaning it is limited. And what is the limit? The Constitution itself. And the Constitution only has 3 instructions to the Senate. Number 1, to constitute itself as an impeachment court once it receives the articles of impeachment, and then to hold impeachment trial. And then the 3rd instruction is to decide to render a verdict of either conviction or acquittal. Those are the 3 specific instructions of the Constitution to the Senate, and nothing else. And that's why I dispute that argument that Senate as an impeachment court similarly has plenary powers.
So you don't believe that plenary rules in this case?
No, because its mandate is specific.
Very quick question, Congresswoman, I have 1 minute left. In the event that the 20th Congress, the impeachment court starts a pretrial, and there is a decision or there is a motion to dismiss based on jurisdiction, and the senators win, that this case, this impeachment case, should be dismissed. What do you plan to do about that? And I ask that, even if it's hypotheticals, because that's clearly being talked about right now. And I'm sure it's something that you
If that happens, and of course I cannot speak officially in behalf of the prosecution panel, but I'm almost sure that the prosecution panel would raise that issue before the Supreme Court. My position has always been that the Supreme Court, as much as possible, should not intervene. It should be sparing, but if there are really very valid issues, constitutional issues like this, you know, whether the Senate as an impeachment court can validly dismiss without trying or without receiving evidence, that is a clear issue of law, clear constitutional issue that the Supreme Court can be asked to intervene. So I'm almost sure that the prosecution cannot just accept that, the dismissal from the impeachment court, and has to raise it before the Supreme Court, the final arbiter.
ML Party List Representative LEILA de Lima. Pleasure to have you, ma'am. Take care of yourself, and we'll see you again. Thank you so much.